We begin with the stunning turn of events out of Washington in just the past hour. FBI Chief James Comey saying no one should face charges over Hillary Clinton's emails. Comey saying no reasonable prosecutor would seek an indictment given the facts of the case.
Although the Department of Justice makes final decisions on matters like this, we are expressing to Justice our view that no charges are appropriate in this case. I know there will be intense public debate in the wake of this recommendation, as there was throughout the investigation. What I can assure the American people is that this investigation was done honestly, competently, and independently. No outside influence of any kind was brought to bear.
But while Director Comey recommends no charges, he faulted Clinton and her subordinates for their handling of classified information, which he says may have fallen into the hands of those he calls hostile actors.
Although we did not find clear evidence that Secretary Clinton or her colleagues intended to violate laws governing the handling of classified information, there is evidence that they were extremely careless in their handling of very sensitive, highly classified information. There is evidence to support a conclusion that any reasonable person in Secretary Clinton's position or in the position of those with whom she was corresponding about those matters should have known that an unclassified system was no place for that conversation.
Meantime, at a rally in D.C. that wrapped up shortly after Director Comey spoke, Hillary Clinton made no mention of the FBI chief's decision. Chief Intelligence Correspondent Catherine Herridge is outside the FBI's headquarters with more on this one. You have been on top of this from the beginning. Tease some of the most important details out for us.
Well, Melissa, what jumped out at me is that the FBI director made his statement this morning without coordinating with other members of the administration and unusually made the statement and then took no questions from reporters. He laid out a very compelling case that there had been violations of 18 U.S.C. 793 subsection F, which is the gross negligence statute, which means the classified information is moved outside of secure channels and there doesn't have to be a threshold for intent. He also said that some of the information did bear classified markings, but nonetheless, he felt that what Mrs. Clinton and her aides had done should have been known to them to be violations in the handling of classified information.
7 email chains concern matters that were classified at the top secret special access program at the time they were sent and received. Any reasonable person in Secretary Clinton's position or in the position of those with whom she was corresponding about those matters should have known that an unclassified system was no place for that conversation.
Director Comey also confirmed for the first time that there were multiple servers that were used by Mrs. Clinton and her aides for government business, and then over the years they had been decommissioned. And once the programs were withdrawn from those hard drives, it became increasingly difficult to recover all of the emails that were in this sort of slack space in the system. He said they did recover many of the emails, but some of them will be lost forever. On the question of whether the server was compromised by a third party or a hostile nation, he said they did not find evidence of that, but they did not expect to either because of the sophistication of these attacks. But they are operating on the assumption that those emails are in the hands of a third party. All of that taken together, the feeling in the room was that he may recommend charges for Mrs. Clinton, but within the last 2 minutes of that news conference, he recommended otherwise.
Although there is evidence of potential violations of the statutes regarding the handling of classified information, our judgment is that no reasonable prosecutor would bring such a case.
So what Director Comey has said is that they did uncover evidence that are possible violations of the federal statutes, but he felt it was of such a nature that the Justice Department would not proceed. Again, what I would emphasize to people is that I have never seen a series of events that unfolded this morning in the 15 years I've been here in Washington covering the FBI, where the director has given such a lengthy statement and again not taking questions when there was obviously interest among the reporters to try and tease out some of the reasons why, specifically what he would say to security clearance holders who were prosecuted or jailed for, on its face, so much less than what Mrs. Clinton and her aides had done, Melissa.
Catherine, let me start with a quick question to you, and then I'll let some other folks here get in on it. You know, he said that she was extremely careless, and when you use that phrase in legal terms, immediately your ears perk up because that is the definition of gross negligence. So it seemed like he was saying we have found gross negligence, which under the statute would bring charges, and then he concluded otherwise. I mean, did I hear that right? Is that what you were hearing along the way too?
Well, what he laid out was their findings, which was they found evidence of a possible mishandling of classified information, which would be under the gross negligence statute and a subsection that does not require intent. Practically speaking, having intent is always better in these cases because it's cleaner from a prosecutor's standpoint, and that this was the findings of 15 months of painstakingly, as he said, going back through the systems and trying to sort of reconstruct or re-engineer. As he said, it was like a jigsaw puzzle where the border had been taken away and the pieces had been thrown on the floor, and it was their job to put it back together. But it's important to emphasize to people that in the course of their investigation, he said they did not find evidence that the deletion of what were deemed to be personal emails was in some way designed to circumvent the system. He did say that the lawyers who deleted the emails deleted them by only reading a header and not the contents of the emails themselves, or by just doing search words looking for emails. So he clearly said, reading in between the lines, that there was not really a thorough or professional search of those emails before they were deleted, and that some of them are in fact lost for good.
Catherine, Jedediah here. I want to talk about this issue that he presented of this information having been born classified, which means that even though there wasn't necessarily an indication that it was classified, she as Secretary of State and people around her should have known that it shouldn't have been conveyed in this manner.
Right.
Does she now have a problem, perhaps not with criminality, but with incompetence now upon hearing these facts?
Well, I don't think I'm in a position to really judge the politics of it, but to lay out what, in fact, he said and what Mrs. Clinton has said in the past. The FBI director said very clearly today that the quality of the intelligence we're talking about, some of it came from special access programs. These are the most closely held government programs, often involve human spying, that this should have been known to her and her aides just as a matter of course, that this was highly sensitive information that could not be discussed outside secure channels. And he also said that the fact that they didn't have classified written on them really makes no difference. The non-disclosure agreement signed by Mrs. Clinton as well as Director Petraeus says that they understand that classified does not have to have any of these kinds of markings. But on a final point, he said they did find emails that had classified markings. And all three, I think, taken together, certainly conflict with what Mrs. Clinton has said publicly. She said nothing she sent or received was classified at the time. The director said that's not the case. She also said nothing she sent or received was marked classified. Now we know that is also not the case. So people are going to have to decide at home, balancing what the director said versus what Mrs. Clinton has said publicly about the case.
There you go. Catherine Herridge, terrific reporting as always. Thank you so much. I want to now bring in Fox News legal analyst Peter Johnson, Jr. He is in our New York newsroom with more reaction to this one. I mean, at the top, when he laid out the case of everything that she had done and her team had done, there were more details, there was more damning evidence in there than what had even been reported.
That's absolutely correct, and Hillary Clinton really should be down on her knees at this very moment, thanking her creator for avoiding an indictment. She came within a hair of an indictment based upon what Mr. Comey said this morning at this press conference. He talked about potential violations of statutes. He talked about extreme carelessness. He talked about dozens, if not 100 or more, top secret, secret and confidential classified emails that were found. He talked about thousands of emails that were not turned over by Secretary Clinton, that were destroyed by her lawyers without even looking at them. So in the end, the FBI director said, well, as a matter of judgment, as a matter of discretion, based on the fact that there was no real sense of espionage or disloyalty, that charges would not be brought. But what the FBI director did, based on this extreme carelessness statement and based upon this cavalcade of missteps, whether intentional or not, depicted a secretary running a culture totally unlike any department in the United States of America, with a total disregard of keeping secrets. And secrets in the Secretary of State's office mean lives very, very often. So this was an extraordinary day. The FBI director parsing his words very carefully, but at the same time depicting, in my mind, what defines gross negligence under the law and could have put Hillary Clinton with an FBI charge and information and then an indictment by a grand jury. Incredible, incredible.
Peter, it's Ebony. I have a question for you as well. Now, according to the FBI director, it looks like criminally they will not be moving forward with her. But, you know, the FBI director also spoke about potential civil sanctions or other security sanctions that she could be facing. Do you have any idea, Peter, as to what that could possibly look like? Because certainly, you know, we haven't even been to conventions yet, so she's a long way from the White House, and how that might impact.
Well, that could impact, but, you know, the Inspector General has already determined that there was a violation of the Code of Federal Regulation with regard to certain statutes here. The greater impact is in having a candidate who has been marked with this scarlet letter, as it were, as an extremely careless Secretary of State who had a conscious disregard for keeping state secrets. And that's a determination and a castigation and a condemnation by the head of the FBI. Clearly, below the surface, and this is just my view of watching him here, he was clearly disgusted by the conduct that was undertaken by the Secretary and by the people around the Secretary. What he's basically saying is, I found potential violation of statutes, but based on precedent, based on past experience, based on the fact that we have never seen anything like this in our lives before, I do not believe that you should go forward, U.S. Attorney's Office in Virginia, with a prosecution. So on one hand saying, we have the evidence, but on the other hand saying, I don't think you can win the case. This is not a clean bill of health. In fact, this is a very sick patient in terms of the statecraft. Very sick.
Peter, it's Tony saying the director actually said there was no precedent for him to charge or bring forward criminal charges. You just used the term precedent. Did the FBI director just create precedent for others in government to operate completely without transparency?
Well, that's a great question. Now, what he said was, well, that doesn't mean that someone in the future who committed essentially the same acts would not be subject to prosecution. So what he's saying is, in this particular unique discrete case, we are recommending no prosecution, in spite of the fact of finding classified secret emails on a personal private server that was not secure. In fact, more than one server, several servers, in spite of finding that thousands of emails had been deleted, and that they, as Catherine Herridge said, we put together this jigsaw puzzle to find all of this. And that's why it took so long. So in a political way, the fallout here is tremendous, because there will be issues about character, trust, conscience, credibility, and the ability to act in a way that is in the best interests of the United States. And clearly, I think the FBI director was concerned about the best interests of the United States in terms of the vulnerabilities that they could not detect based on the time and the way this data was now kept. Yeah, no, it's Melissa. Before we